Forget propaganda. This isn't a staged Reich production. These are raw, shaky frames captured by American soldiers as they stumbled into the abyss. Dachau, Buchenwald, Mauthausen. The lens catches everything: skeletal survivors, open mass graves, and bodies stacked like cordwood. In this courtroom, 7 men are watching these screens and realizing one thing: they are looking at their own death warrants. December 9th, 1946. Nuremberg, Bavaria. The Palace of Justice. Second floor, courtroom 600. Behind thick stone walls that had survived Allied bombing, the world's first international medical tribunal convened. 23 defendants arranged in tiered seating. Their faces bore no obvious marks of cruelty. Most wore suits, not uniforms. Some took notes on legal pads. Others whispered to their attorneys. They could have been attending an academic conference. Karl Brandt sat in the front row. Age 42, Hitler's personal escort physician. Clean-shaven, rimless spectacles, the bearing of a university lecturer. Before the war, he'd shown promise as a surgeon. Now he faced charges of mass murder disguised as medical research. Beside him, Victor Brack, 37 years old, SS Oberfuhrer, the bureaucrat who'd transformed euthanasia from theory into industrial-scale killing. He'd signed orders. He'd allocated budgets. He'd coordinated personnel. His handwriting appeared on hundreds of documents authorizing what the regime called mercy deaths. Joachim Mrugowski, chief hygienist of the Waffen-SS, academic credentials from Munich and Berlin, published researcher. He'd overseen typhus experiments that killed prisoners by the hundreds, documenting their agonies with clinical precision. Karl Gebhardt, personal physician to Heinrich Himmler, orthopedic surgeon. He'd operated on Reinhard Heydrich after the assassination attempt. When Heydrich died from infection, Gebhardt decided to experiment. He deliberately infected wounds of female prisoners at Ravensbrück to test sulfanilamide treatments. Many died screaming. Waldemar Hoven, Buchenwald's chief physician. He'd administered phenol injections to prisoners, sometimes to test drug toxicity, sometimes just to clear hospital beds for incoming patients. Rudolf Brandt, Himmler's personal administrative secretary. No relation to Karl Brandt, but equally embedded in the machinery. He'd coordinated experiments across the camp system, ensuring supplies, personnel, and documentation flowed smoothly. Wolfram Sievers, director of the Ahnenerbe Institute, supposedly dedicated to ancestral research. In practice, he'd organized skeleton collection programs, high-altitude experiments, and mustard gas tests on prisoners. 7 men. By trial's end, 7 death sentences. Now you might be thinking this was straightforward. They committed atrocities. Evidence proved it. Justice followed. Stop for a second. Because what made this trial unprecedented wasn't just what they did, it was how the prosecution proved it. Telford Taylor, the American chief counsel, understood something crucial. Chief counsel Telford Taylor knew the game. Witnesses can be intimidated. Documents can be called fakes. But the film? You can't cross-examine a camera. The footage created a foundation the defense couldn't touch. It spoke a language beyond testimony, a language that made denial physically impossible. December 13th, 1946. 4 days into the trial. The prosecution calls for the projection equipment to be prepared. Defense attorneys object. They argue that films are prejudicial, that they inflame emotions rather than establish facts. Judge Harold Sebring overrules them. The evidence is relevant, he states. The tribunal will assess its probative value. The projector is wheeled into position. A white screen descends along the courtroom's eastern wall. The lights dim. And for the next 70 minutes, the defendants watch as American prosecutors narrate over footage that documents the consequences of their research. The reel begins with liberation footage, April 1945, U.S. Army Signal Corps cameraman entering Dachau with the 45th Infantry Division. The camera is unsteady. Whoever's filming is trying to process what he's seeing. Boxcars packed with corpses. Prisoners weighing 60 pounds, barely alive. The crematorium ovens still warm. Then the footage shifts. This isn't liberation material. This is Nazi documentation. SS photographers had filmed medical experiments. Not all of them, but enough. Enough to create a visual record that prosecution teams discovered in captured archives. High-altitude experiments at Dachau. Prisoners placed in low-pressure chambers, simulating altitudes of 40,000 feet. The camera captures their convulsions as oxygen deprivation destroys their brains. Some footage shows doctors in white coats standing beside the chamber, clipboards in hand, timing the duration until unconsciousness, until death. Freezing experiments, prisoners immersed in ice water for hours. Thermometers inserted rectally to measure core temperature drop. The footage shows men shaking violently, their skin blue-white, their eyes vacant. In some frames, you can see doctors injecting stimulants, trying to revive subjects, not to save them, but to prolong the experiment. The courtroom is silent except for the projector's mechanical clicking. Some defendants stare at the screen, others look down at their hands. Karl Brandt's jaw tightens. He knows what's coming. Because here's what the prosecution does next. They don't just show atrocity footage. They connect it to the defendants. Telford Taylor stands, pointer in hand. He directs the judge's attention to specific frames. "You'll notice the physician on the left," Taylor says, his voice measured, clinical. "That's Dr. Sigmund Rascher, who conducted the high-altitude experiments under authorization from defendant Karl Brandt and Heinrich Himmler." He clicks to another frame. "The documentation recovered from Dachau includes reports addressed directly to Brandt's office. The experiments you're witnessing were authorized from the highest levels." Taylor introduces documents matching the footage, letters from Brandt approving Rascher's research proposals, budget allocations for equipment, personnel transfers. The paper trail runs parallel to the visual evidence, each reinforcing the other. You can't dismiss the footage as isolated incidents when documents prove systematic coordination. Consider what that implies. The defense strategy had been predictable. These men planned to claim they were following orders, that wartime necessity justified extreme measures, that they were isolated from broader policy decisions. But the U.S. footage, combined with captured Nazi documentation, obliterated that defense, because the prosecution could show the judges exactly what following orders meant. It meant authorizing experiments where prisoners were frozen to death. It meant reviewing reports where mortality rates were listed in neat columns. It meant reading clinical descriptions of human agony and responding with requests for more data. The footage continues. Ravensbrück concentration camp, the sulfanilamide experiments. The camera shows women prisoners, their legs deliberately wounded, the wounds infected with bacteria, wood shavings, and glass fragments to simulate battlefield injuries. The infections are allowed to progress. Gangrene sets in. Some receive experimental treatments. Many don't. The footage captures bandages soaked through with pus, limbs blackened with necrosis. In one frame, you can see a woman's face contorted in pain as a doctor removes her bandages for documentation purposes. Prosecutor James McHaney stands. "The woman you see in this frame is Jadwiga Zito. She survived these experiments. She's here in Nuremberg. She'll testify." And later in the trial, she does. She shows the judges her scars. She identifies Karl Gebhardt as the physician who supervised her torture. But the footage matters because it proves she's not fabricating, not misremembering. The camera captured what was done to her and dozens of others. Here's the detail that changed everything. The Nazis had filmed these experiments for documentation, for training, for demonstrating research findings to military medical conferences. They had created an archive, an evidence library of their own crimes. And when American forces captured SS medical facilities, when they secured research institutes and administrative headquarters, they found canisters of film labeled with clinical precision. Hypothermia research, Dachau, 1942. Sulfanilamide trials, Ravensbrück, 1943. Typhus vaccine development, Buchenwald, 1944. The Third Reich's obsession with documentation became its own indictment. The Americans didn't need to reconstruct what happened. The perpetrators had filmed it themselves. Telford Taylor understood the power of this. Testimony could be challenged on cross-examination. Survivors might have faulty memories or emotional biases. Documents could be dismissed as forgeries. But footage, especially footage, created by the defendant's own colleagues, was irrefutable. The camera didn't lie. It couldn't be cross-examined. It showed what happened, preserved in black and white. Undeniable. Hold that thought. Because there's another layer here. The prosecution didn't just use Nazi footage. They used American liberation footage to show the scale, to demonstrate that these weren't isolated experiments. They were part of a broader system that reduced human beings to laboratory materials. The projector shows Buchenwald after liberation. American soldiers walking through barracks, their faces stunned. Prisoners who can barely stand. The pathology department where organs from executed prisoners were preserved in jars, labeled and cataloged. The crematorium where bodies were burned. And then, crucially, the administrative offices where records were kept. Rows of filing cabinets, thousands of documents, names, dates, experimental protocols, results. The camera lingers on these details. The Americans who filmed this understood they were documenting evidence for future prosecution. They moved slowly, methodically. They filmed signs in German, then filmed translators explaining what they said. They filmed documents spread across desks, zooming in on signatures and official stamps. They filmed survivors willing to speak, recording their testimony on site, in the camps, before memories could fade or be challenged. This was evidentiary filmmaking. The cameramen weren't journalists looking for dramatic footage. They were creating a visual record that could withstand legal scrutiny. When this footage plays in the Nuremberg courtroom, the judges see not just atrocities, but chain of custody. They see American soldiers discovering evidence in situ. They see documentation that connects experiments to specific camps, to specific doctors, to specific dates. The footage establishes context, proves provenance, demonstrates scale, and that's where it turns. Because Joachim Rogowski's attorney stands during a recess. He objects again. He argues that the footage is inflammatory, that it prejudices the tribunal against his client. Judge Sebring asks a simple question. Is the footage inaccurate? The attorney hesitates. No, Your Honor, but Sebring cuts him off. Then its emotional impact doesn't render it inadmissible. These defendants are charged with conducting criminal medical experiments. The prosecution is entitled to show the tribunal what those experiments looked like. The objection is overruled. The footage continues. Typhus experiments at Buchenwald. The footage shows Mrugowski's work, prisoners deliberately infected with the disease, medical staff recording symptoms, fever charts documenting temperature spikes, mortality logs listing names and dates. The camera captured clinical detachment, doctors observing prisoners as they convulsed, as rashes spread across their bodies, as organs failed. In some frames, you can see physicians taking blood samples from dying subjects, still collecting data even as their research subjects expired. The prosecution presents documents alongside this footage, letters from Mrugowski to Heinrich Himmler reporting progress, budget requests for additional subjects, discussions of which prisoner populations would be most suitable for infection, Jews, Poles, Soviet POWs. The language is bureaucratic, sanitized. Material instead of prisoners. Units instead of human beings. But the footage strips away the euphemisms. It shows what units actually meant. Men dying in agony while doctors took notes. Let that land. The defendants had spent months constructing their defense. They were scientists. They were advancing medical knowledge under difficult wartime circumstances. They were trying to save German soldiers from diseases that killed thousands on the Eastern Front. Typhus was devastating Wehrmacht units. Someone had to develop vaccines. Prisoners were going to die anyway in the camps. Why not make their deaths meaningful by contributing to medical progress? That was the defense. Utilitarian logic, the greater good, wartime necessity. And it might have gained traction with the judges, who were military officers themselves, who understood battlefield medicine, who'd seen the brutal pragmatism that war demanded. Except the footage made that argument impossible. Because what the judges saw wasn't battlefield medicine. It was systematic torture documented with scientific precision. It was suffering prolonged for data collection purposes. It was human beings reduced to test subjects without consent, without dignity, without any consideration for their humanity. The part nobody anticipated was how the footage would affect the defendants themselves. Some had convinced themselves that what they'd done was defensible, that history would judge them as pioneers who made difficult choices, that the Hippocratic Oath had to bend during total war. But watching the footage forced confrontation with reality. Karl Gebhardt had written in his diary about the Ravensbrück experiments as groundbreaking research into infection pathology. Now he was watching women scream as their legs rotted. Waldemar Hoven had described his phenol injections as medically necessary selections. Now he was seeing footage of prisoners collapsing as poison stopped their hearts. Some defendants looked away. Victor Brack closed his eyes during the high-altitude footage. Rudolf Brandt studied his legal documents instead of watching the screen. But the judges noticed. They noted who couldn't face the evidence, and that became part of their calculus. If these men couldn't watch footage of their own work, what did that say about their claims of scientific necessity? American prosecutor Alexander Hardy made this point explicit during his closing argument. The defendants ask you to view their experiments as medical research. But research requires that investigators can face the results of their work, can present findings publicly, can stand behind their methodology. Notice how many of the defendants cannot even watch the footage of experiments they authorized, supervised, and documented. That tells you everything you need to know about whether they truly believed their work was ethically sound. The footage library the Americans had captured was vast. Over 40 hours of material. The prosecution couldn't show all of it. They selected sequences that established key elements, command structure, systematic coordination, the transition from individual criminal acts to system-wide policy. And they used Nazi footage alongside American liberation footage to show cause and effect. Here's the experiment being conducted. Here's what happened to the subjects. Here's what American soldiers found when they liberated the camp. Seawater experiments at Dachau. Nazi footage showed prisoners forced to drink only seawater for weeks. The camera documented weight loss, kidney failure, psychological breakdown. Some prisoners were filmed licking moisture off the walls. Others begged for fresh water in footage captured by SS medical staff. The Americans found survivors of these experiments, filmed them at liberation, showed the permanent kidney damage, the neurological impairment. The before and after became an indictment. Stop for a second. Consider the psychology of the judges watching this. Harold Sebring had been a justice on the Florida Supreme Court. Walter Beals had served on the Washington State Supreme Court. Johnson Crawford was a district court judge from Oklahoma. These were not men accustomed to sensational evidence. They'd presided over murders, robberies, rapes. They'd seen crime scene photographs. They'd heard disturbing testimony. But this was different in kind. This was industrialized cruelty. This was atrocity systematized and documented by the perpetrators themselves. The footage didn't just prove specific criminal acts. It proved intent. It proved knowledge. It proved that these defendants understood exactly what they were authorizing. Because why document experiments if you don't understand their nature? Why film prisoners dying if you're not aware they're dying? Why preserve footage in labeled canisters if you're not maintaining records of specific research protocols? The defense couldn't explain this away. They tried. Karl Brandt's attorney argued that documentation was standard scientific practice, that filming experiments proved they were being conducted openly, that there was no criminal consciousness of guilt. But the prosecution had a devastating counter. If these experiments were legitimate medical research, why weren't they published in medical journals? Why weren't they presented at international conferences? Why was the documentation kept in SS archives rather than shared with the broader medical community? Silence, because everyone in that courtroom knew the answer. These experiments were documented for internal use only, for training SS physicians, for reporting to Himmler and Hitler, for creating an institutional knowledge base that would remain hidden from external scrutiny. The footage wasn't evidence of scientific openness. It was evidence of systematic concealment. And that's where it gets crucial. The Americans had also captured administrative footage, SS training films showing medical officers how to conduct selections, how to administer lethal injections, how to document experimental results. This footage wasn't from concentration camps. It was from SS medical schools, from training facilities, where young doctors learned how to implement the regime's policies. The prosecution showed these training films to establish that the experiments weren't aberrations. They were curriculum. They were being taught to the next generation of SS physicians as standard methodology. What the film quietly proves is that the defendants weren't isolated criminals. They were educators. They were systematizers. They were building an institutional framework where medical atrocity would be normalized, perpetuated, expanded. Karl Brandt had authorized experiments, but he'd also authorized the training programs that would ensure those experiments continued. Mrugowski hadn't just conducted typhus research. He developed protocols that other SS physicians would follow at other camps. Gebhardt's sulfanilamide experiments at Ravensbrück became templates for infection research at Auschwitz and Mauthausen. The footage showed this network. Training films referenced experiments documented in other footage. Reports mentioned findings from multiple camps. Personnel appeared in footage from different locations, showing how doctors rotated between facilities, spreading knowledge and methodology. The prosecution built a visual argument. This wasn't a collection of individual crimes. This was a system, and these 7 defendants, along with the others, were architects of that system. February 1947. 2 months into the trial. The prosecution has shown over 30 hours of footage. The defense begins its case, and they try a different approach. They present their own footage, German medical instructional films from before the war, surgical techniques, public health campaigns. They're trying to establish that German medicine had a proud tradition, that these defendants had been part of a legitimate medical establishment before the regime corrupted it. That context matters, that they were victims of circumstance, not architects of atrocity. Judge Sebring allows the footage, but the effect backfires, because the contrast is devastating. Pre-war German medical films show careful ethical procedures, patient consent, sterile environments, respect for human dignity. And then the prosecution simply replays the concentration camp footage. The judges see exactly how far German medicine fell, how completely it was perverted, and that makes the defendant's guilt worse, not better. Because they knew what ethical medicine looked like. They'd been trained in it, they'd practiced it, and they'd abandoned it anyway. The prosecution hammers this point. They call expert witnesses, American military physicians who served in combat. They testify about battlefield medicine, about making life and death decisions under fire, about the ethical constraints that persisted even in extremity. And then Prosecutor McHaney asks the question, did you ever, under any circumstance, conduct medical experiments on prisoners without consent? Every witness answers the same way. No, never. That would violate everything we're sworn to uphold. I doesn't. The defense's utilitarian argument collapses, because the judges see that even under wartime pressure, even in desperate circumstances, ethical medicine was possible. The defendants had choices. They chose atrocity. March 1947. The defense presents Karl Brandt's personal testimony. He takes the stand for 6 days. He's articulate, composed. He explains the T4 euthanasia program as a mercy initiative. He describes the pressure from Hitler, the impossible position he was in. He claims he tried to maintain medical ethics within the constraints imposed by the regime. And then the prosecution shows footage, Nazi propaganda films about the T4 program, films designed to convince the German public that killing disabled citizens was compassionate, films that Brandt himself had helped produce. The footage shows disabled children described as life unworthy of life. It shows psychiatric patients characterized as economic burdens. It shows carefully crafted imagery designed to dehumanize victims, to make their murder seem reasonable, even necessary. And the narration in these films uses medical language, genetic health, racial hygiene, Therapeutic intervention. The propaganda weaponized medical terminology to justify mass murder. Telford Taylor cross-examines Brandt while the footage plays on a loop behind him. You helped create these films? Taylor asks. Brandt admits he advised on medical content. You approved the terminology? Brandt hesitates, then confirms. So you weren't just following orders. You were shaping public perception. You were building the ideological framework that made mass murder acceptable. Brandt has no effective response. The footage proves he wasn't a passive instrument. He was an active participant in constructing the regime's medical justifications. He'd taken medical science and perverted it into propaganda, and the T4 program he'd helped build became the testing ground for Auschwitz. The gas chambers, the selection protocols, the crematoriums, all refined first in psychiatric institutions before being scaled up for genocide. That's the through line the prosecution establishes with footage. It's not just about individual experiments. It's about showing how German medicine became a tool of genocide, how physicians transitioned from healers to killers, how medical science was corrupted into racial ideology. And the footage traces that progression. Training films showing doctors learning to make selections. Propaganda films normalizing euthanasia. Documentation footage showing experiments in concentration camps. Liberation footage showing the final result. Mountains of corpses, survivors barely alive. The complete destruction of medical ethics. May 1947. Closing arguments. The defense makes its final appeal. They argue that prosecuting doctors for following government orders sets a dangerous precedent, that medical ethics are culturally variable, that judging 1940s German physicians by 1947 standards is unfair, that the real criminals were Hitler and Himmler, both dead, and these defendants were merely instruments. Alexander Hardy delivers part of the prosecution's closing. He's prepared a visual presentation. He shows footage sequences side by side. On one screen, Nazi propaganda showing Hitler as a caring leader, concerned with German health and welfare. On the other screen, liberation footage from Dachau. This is what caring looked like in the Third Reich, Hardy says. The defendants want you to believe they were trapped in an impossible situation, but they weren't imprisoned in concentration camps. They were the ones imprisoning others. They weren't experimented on. They were the experimenters. They had medical degrees, resources, authority. They could have refused. They could have resigned. They could have done nothing, which would have been better than what they did. The footage runs as Hardy speaks. The contrast is unbearable. Nazi training films showing confident doctors. Liberation footage showing their victims. The judges take notes. Some defendants stare straight ahead, faces blank. Others whisper urgently to their attorneys. What they didn't expect was the judge's response to the footage, because Judge Sebring asks for something unusual. He requests that specific sequences be shown again during deliberations. The high-altitude experiments, the sulfanilamide trials, the typhus research. He wants the tribunal to review the footage alongside the documentary evidence, to see how the visual record corroborates written reports. This is unprecedented. Appeals court judges review transcripts and documents. They don't typically rewatch exhibits, but Sebring understands that the footage captures something the written record cannot. It shows the human cost. It makes abstract statistics concrete. It forces the tribunal to confront not just legal questions, but moral ones. August 19th, 1947. The judges deliberate for 4 days. Rumors circulate through Nuremberg. Some observers expect acquittals or light sentences. After all, these are doctors, not concentration camp commandants. Some predict a few convictions with long prison terms. Almost no one expects death sentences. August 20th, 1947. The defendants are brought into the courtroom. The public gallery is packed. Journalists fill the press section. Judge Sebring begins reading the verdict. He starts with the legal framework. The tribunal has determined that certain acts constitute crimes against humanity, regardless of whether they violated the perpetrator's domestic law. Medical experiments without consent constitute such crimes. Murder disguised as medical research constitutes such crimes. Then he addresses the defendants individually. Karl Brandt. You were not a mere functionary. You shaped policy. You authorized programs. The evidence, including extensive film documentation, proves you understood the nature and consequences of your actions. Guilty on all counts. Sentence, death by hanging. The courtroom erupts. Brandt stands motionless. His attorney grips the table. The gallery murmurs. Guards restore order. Victor Brack, guilty, death by hanging. Rudolf Brandt, guilty, death by hanging. Karl Gebhardt, guilty, death by hanging. Joachim Rogowski, guilty, death by hanging. Waldemar Hoven, guilty, death by hanging. Wolfram Sievers, guilty, death by hanging. 7 death sentences, 5 life sentences, 4 long prison terms, 7 acquittals. The judges read their written opinion over 2 hours. They cite the footage repeatedly. The filmed evidence demonstrates systematic coordination. The visual record corroborates survivor testimony. The defendant's own documentation proves their crimes beyond reasonable doubt. But then Judge Sebring does something remarkable. He announces that the tribunal has drafted a code of ethics for medical research. 10 principles: informed consent, voluntary participation, the right to withdraw, minimization of harm, proportionality between risk and benefit, qualified researchers, proper facilities. These principles aren't just for Germany, they're universal. They apply to all medical research, in all nations, for all time. This becomes the Nuremberg Code, the first international standard for medical ethics. And it emerges directly from watching the footage, from seeing what medicine becomes when ethics disappear, from understanding that the Hippocratic Oath needs enforcement mechanisms, not just aspirational language. The defense attorneys immediately file appeals. They argue the sentences are disproportionate. They claim ex post facto prosecution. They assert that the Nuremberg Code is being applied retroactively. Every appeal is denied, because the judges make a distinction. The code isn't creating new crimes. It's articulating principles that existed all along. Principles embedded in medical tradition, in basic human dignity and natural law. The defendants didn't violate novel standards. They violated fundamental ethics that every physician inherently knows. June 2nd, 1948. Landsberg Prison. The 7 condemned men are executed. Master Sergeant John C. Woods operates the gallows. The executions are filmed by U.S. military cameramen, not for public release, for official records. The footage is classified. It remains classified today. Some footage eventually leaks, but the U.S. government maintains that executions should not become public spectacle, even when the condemned are war criminals. There's bitter irony here. The Nazis filmed their experiments, creating evidence that condemned them. The Americans filmed the executions, but suppressed the footage. 2 different philosophies of documentation. One regime filmed atrocity as standard procedure. Another regime filmed justice, but kept it sealed. The aftermath raises questions that persist today. Of the defendants who received prison sentences, most were released early. By 1955, fewer than 10 years after conviction, many were free. The Cold War shifted priorities. The Americans and Soviets competed for German scientific talent. Operation Paperclip brought Nazi scientists to the United States. Some had participated in experiments. Their records were sanitized. Their expertise was valued more than their past. This complicates the narrative. 7 doctors hanged for medical war crimes, but dozens of others who participated in similar research were recruited, relocated, employed by the victorious powers. The footage shown at Nuremberg proved systematic atrocity, but geopolitics determined who faced consequences and who received second chances. Consider what that means for justice. The Nuremberg Code established universal principles, but enforcement was selective. The doctors executed at Landsberg were found guilty of specific documented crimes, but the broader system that enabled them involved hundreds of physicians. Most were never prosecuted. Some continued medical careers. A few even returned to academic positions in the 1950s and 1960s, though typically not in Germany, where their names carried infamy. The footage archives remained. The Americans transferred them to the National Archives. Researchers could access them with restrictions. Film students, historians, documentary makers. The footage appears in Holocaust education materials, carefully edited, context added, warnings about graphic content. Because the same images that served as evidence at trial now serve as historical documentation. They ensure that denial becomes impossible. You cannot claim the Holocaust was exaggerated when cameras captured it. But here's what troubles ethicists. The footage exists because Nazis filmed experiments. They documented their victims' suffering, which means watching the footage, even for educational purposes, continues a violation. Those prisoners never consented to being filmed. They never agreed that their torture would become historical record. Modern archivists struggle with this. Should the footage be preserved? Should it be shown? Or does displaying it perpetuate the original crime? There's no perfect answer. Suppressing the footage risks allowing denial to flourish. Showing it risks exploiting victims again. The compromise has been controlled access. Researchers can view unedited archives with justification. Educational materials use brief, carefully selected sequences. The full horror remains mostly unseen, documented but not publicly displayed. The Nuremberg Code itself had a strange trajectory. Established in 1947, celebrated as a landmark in medical ethics, but not immediately adopted. The United States didn't formally implement it as federal policy until the 1970s. It took another scandal, another revelation of medical experiments without consent. The Tuskegee syphilis study. 1932 to 1972, U.S. Public Health Service, 600 African American men in Alabama. Some had syphilis. They were never told their diagnosis. They were never treated, even after penicillin became widely available in the 1940s. Researchers wanted to study the disease's natural progression. They observed as men went blind, developed neurological damage, died, all while effective treatment existed. When the study was exposed in 1972, journalists drew immediate parallels to Nazi experiments, not equivalent in intent or scale, but equivalent in the fundamental violation. Using human beings as research subjects without informed consent, treating patients as data sources rather than autonomous individuals. The outcry was immediate. How could this happen in America? How could the nation that prosecuted Nazi doctors tolerate similar ethical violations at home? The US didn't adopt the code because it wanted to be moral. It adopted it because it got caught. The Tuskegee revelations forced a reckoning. Congressional hearings, new regulations, institutional review boards, mandatory informed consent. All the principles established at Nuremberg, finally implemented 25 years later. The footage from concentration camps had proven that medical ethics needed formal enforcement. But it took domestic scandal to catalyze actual reform, which brings us to the uncomfortable present. Medical ethics today exists in tension. The Nuremberg Code provides clear principles, but real-world application gets complicated. Emergency medicine sometimes requires treatment without explicit consent. Public health crises demand population-level interventions. Research into diseases affecting vulnerable populations raises questions about meaningful consent when participants face extreme poverty or limited alternatives. These situations aren't comparable to Nazi experiments. The differences in intent, oversight, and ethical review are fundamental. But the underlying tension is identical: individual autonomy versus collective benefit. Where do we draw lines? Who decides? COVID-19 amplified these questions. Vaccine development at unprecedented speed, emergency use authorizations, debates about mandates, discussions about acceptable risk levels. Again, none of this resembles concentration camp experiments. But the Nuremberg Code kept appearing in debates. Anti-vaccine activists invoked it, often inappropriately. Public health officials referenced it to explain informed consent requirements. Medical ethicists used it to discuss the balance between individual choice and community protection. The code remains relevant precisely because the temptations it guards against persist. Not the temptation toward genocide, but the temptation to prioritize collective outcomes over individual dignity, to decide that some suffering is acceptable if it produces useful knowledge, to convince yourself that subjects benefit from participation even when they haven't meaningfully consented. Those temptations exist in every society, in pharmaceutical research conducted in developing nations where regulatory oversight is weak, in AI-driven medical diagnosis, where algorithms are trained on patient data without explicit consent, in genetic research where tissue samples collected for one purpose get used for another. None of these are atrocities, but all of them test the boundaries established at Nuremberg. The footage still matters because it shows where boundary violations lead. It documents the endpoint of medicine without ethics. It makes abstract principles concrete. When medical students learn about informed consent, many watch edited sequences from the Nuremberg evidence, not to traumatize them, but to ensure they understand why these principles exist, why shortcuts are dangerous, why the Hippocratic commitment to first do no harm requires constant vigilance. 78 years after the trial, Courtroom 600 still exists. It's preserved as a museum. Visitors can sit in the gallery where journalists watch the proceedings. They can see the defendant's dock. They can stand where Telford Taylor stood. And in the museum's archive room, they can view selected footage from the trial. Not the most graphic sequences, but enough to understand what the judges saw, enough to grasp why 7 doctors were hanged. The question that haunts every visitor is the same question the judges faced. How did educated, trained, credentialed physicians become torturers? How did men who took oaths to heal decide to harm? How did medical science transform into medical murder? The answers aren't simple. The defendants weren't sadists who sought out opportunities for cruelty. They were careerists who accepted the regime's framework. They were researchers who convinced themselves that advancing knowledge justified extreme methods. They were professionals who compartmentalized their work from their conscience. They were human beings who made choices, step by step, that led to atrocity. The footage captured those choices. Doctors standing beside pressure chambers, watching prisoners die. Physicians infecting wounds, documenting the progression of gangrene. Researchers injecting typhus, recording mortality rates. In every frame, you see men who chose this work, who could have refused, who could have resigned, who could have done nothing which would have been infinitely better than what they did. And that's the lesson that extends beyond Nuremberg. Evil doesn't require monsters. It requires ordinary people who accept extraordinary justifications, who convince themselves that this situation is unique, that normal rules don't apply, that the ends justify the means. Now, the Nazis provided those justifications. They created an entire ideology around racial health, genetic purity, national survival. And educated professionals accepted it, not because they were coerced, because it offered status, resources, career advancement. The footage proves this. You don't see SS guards forcing doctors to conduct experiments. You see doctors volunteering, competing for research funding, publishing findings in SS medical journals. The system incentivized atrocity, and professionals responded to those incentives. Modern medicine has safeguards, institutional review boards, ethics committees, informed consent protocols, external oversight. These exist because of Nuremberg, because the footage showed what happens without them. But safeguards only work if people maintain them, if ethical drift is identified early, if professionals refuse to normalize violations even when institutions pressure them. That's the continuing relevance of the doctor's trial, not as ancient history, as ongoing warning. The capacity for medicine to be perverted still exists. The temptation to prioritize outcomes over individuals hasn't disappeared. The risk that professionals will accept unethical frameworks if they're presented with sufficient authority and justification remains real. The 7 executed doctors weren't uniquely evil. That's what makes their story terrifying. They were doctors like many others, trained at respected universities, published in peer-reviewed journals, respected by colleagues, and they became war criminals. The transformation wasn't instant. It was gradual, small compromises, incremental boundary violations, each step rationalized by the previous one, until they were conducting experiments that killed hundreds and documenting it all on film. June 2nd, 1948. 7 bodies on 7 gurneys. 7 doctors executed for crimes they'd committed while wearing white coats. The footage that convicted them remains in archives, preserved as evidence, as education, as warning. Thousands of feet of film showing what medicine becomes when ethics vanish. And here's the question that trial forces on anyone who watches that footage. Could you resist? If you were a physician in 1940s Germany, if your career depended on cooperation, if authorities insisted these experiments were necessary, legal, justified, if colleagues participated without consequence, if the regime framed resistance as betrayal, would you refuse? Most people believe they would. The judges at Nuremberg believed the defendants should have. The Nuremberg Code assumes physicians can and must refuse unethical demands regardless of pressure. But history suggests otherwise. Most German doctors cooperated. Most accepted the regime's framework. Most found ways to rationalize participation. The footage doesn't let you look away from that reality. It shows doctors who probably believed they were good people making difficult choices under impossible circumstances. It shows what those choices actually meant. Bodies, suffering, systematic destruction of human dignity in the name of medical science. That's why the US footage and the captured Nazi footage mattered so much at trial. Why they still matter. They make denial impossible. They transform abstract ethical principles into concrete visual evidence. They show the judges and show us exactly what's at stake when medicine abandons ethics. Would the 7 doctors have been convicted without the footage? Possibly. The documentary evidence was extensive. Survivor testimony was powerful. But the footage made convictions certain, made death sentences defensible, made the judge's decision to establish universal ethical principles urgent and necessary. 78 years later, that urgency persists, because the Nuremberg Code isn't self-enforcing, because medical ethics require constant defense, because the footage reminds us what happens when we fail. Do you think visual evidence should carry more weight than documentary or testimonial evidence in war crimes trials? Or does footage risk being too inflammatory, prejudicing tribunals against defendants? Drop your perspective below. And if this examination of how American prosecutors used film to secure justice revealed something you hadn't considered about the Nuremberg legacy, subscribe. Episode 2 explores what the defense footage tried to prove and why it backfired so catastrophically that it strengthened the prosecution's case. I'll see you in the next one.